Good afternoon, everyone. It's our pleasure to have you on joining us today. I'm Phạm Hoàng Huy from TND Legal, who will be the host for today's 60 minutes webinar on law regulating business and foreign investment in Vietnam. Today, sponsored by Work Law Alliance. And first of all, I'll walk through the coverage of today's webinar. There will be three topics. The first is market access restriction. The second topic is the overview licensing procedure in respect of foreign investment. And the third topic is the marketplace lending regulatory environment in Vietnam. Our panelists today comprise of Mr. Võ Hữu Tú. Mr. Tú is the partner of TND Legal, and he's a qualified lawyer with 12 experience in legal professional who has been advising many foreign investors and foreign invest companies on various legal matters. Before co-founding TND Legal, Mr. Tú worked for Ludwig Advocates and Solicitors and Indochin Counsel, two of the current leading commercial law firms in Vietnam. And Mr. Tú will lead the discussion on the first section of market restriction. And the second panelist is Mr. Nguyễn Văn Dư. Mr. Dư is the senior associate of TND Legal. He has experience in corporate and commercial matter, inward investment, and M&A transaction, especially in the field of education, real estate, good trading, and renewable energy. Dư has almost 8 years working at top-tier commercial law firms in Vietnam. Mr. Yu will lead the discussion on the section of overview licensing procedures for foreign investor in Vietnam. And the last panelist will be Mr. Nguyễn Quốc Bảo. Mr. Bảo is the senior associate and head of business development of TND Legal. And Mr. Bảo obtained his master's degree from University of Kent in 2020 and has cooperated with TND Legal for almost 2 years. He specialized in inward investment, corporate, commercial, and M&A transaction, especially in the sector of fintech, renewable energy, and education. And he will lead the discussion on the section of the marketplace lending regulatory environment in Vietnam. Then I would like to remind the audience that if you have any questions, or there's any point that you want the panelists to focus on, please feel free to submit your questions via the Q&A function, which you can see on your screen, so that the panelists can answer later at the end of the panelist discussion. However, please note that due to the limitation of time, the panelists can only answer as many questions as possible on a first-come, first-served basis. So any question which cannot be answered in this webinar should be directed to our email at info@tndlegal.com, and the panelists will give their best effort to provide answer to you. And without keeping you on waiting any longer, we'll kick off the panelist discussion beginning with the market access restriction led by Mr. Võ Hữu Tú. Hello, Mr. Tú.
Hello.
Yeah. The first question for you. Many foreign investors wonder about the rules on investment condition and market asset restriction, especially when the law on investment 2020 come into force. So could you please share with us some more about that?
Sure. First of all, I would like to thank you all for joining us on the webinar today. Back to the question, sure. The law on investment 2020 took effect on the 3rd January last year, 2021, and we may observe several notable points related to the new laws as below. First, I would like to talk about the sector in which foreign investment is prohibited or conditional. Under the new law on investment, foreign investors are not allowed to invest in sectors that fall within the list of sectors in which foreign investment is prohibited. Moreover, if a foreign investment is made in a sector that falls under the list that foreign investment is subject to market asset condition, we normally call them as conditionalists. Such investment is allowable only when the investor meets relevant market asset condition. There currently are 25 sectors prohibiting foreign investor from invested in, and 59 sectors that are investment is conditional to foreign investor.
Yes, I heard about the two lists too. Would they be updated from time to time?
Absolutely. These two lists will be updated from time to time to reflect the change in or issue of the new law, local law, or international treaty to which Vietnam is a party.
Thank you. Please continue with your points. I see that you have a first point, right? So what is the second point?
Yeah. The second notable point under the new law on investment that I would like to share with you all today is about licensing requirement for unbound sectors. Under the formal law on investment, foreign investors who wish to engage in sectors which are unbound or have not been committed under the international treaty were required to obtain industrial approval from relevant ministry in Hanoi as part of the investment approval process. Such industrial approval is indeed granted on a case-by-case basis. However, now under the new law, it appears that foreign investment in unbound sectors is no longer subject to the relevant ministry industrial approval on a case-by-case basis, but it is only subject to the market asset restriction as clearly regulated under the local law.
Oh, interesting. So I think the above development are for a good for the foreign investment, which have shortened the time needed for licensing procedure, right?
Apparently, the new rules is a very positive development indeed.
Mr. do you have anything to share with us?
Yeah, I think what Mr. Tu has shared covers pretty much of the new rules adopted by the new investment law. Just to add something that I think it reflects the macro policy of Vietnam, whereby, as many of you can see, the new generation FTA and MTA have recently been signed and adopted, namely some of a CPTPP or UK FTA or even EU FTA. So they reflect the shift from a positive approach to a negative approach on market entry requirements, and it opened up the sector to the foreign investor. But I think what we should consider of interest is that how the licensing authority will interpret and try to change the mindset that has been subsisted for them for even more than 15 years. And I think there might be a gap between the legislative text as well as the practical approach from the some type line authorities. Yeah.
Yes.
Okay, that's interesting, and thank you, Bao, for sharing that with all of us. The final things among the changes under the new law on investment that I would like to share today is a national defense and security review. National defense and security review is one of the most notable points introduced under the new laws on investment. In particular, approval from the Ministry of National Defense and Ministry of Public Security must be obtained for foreign investors who implement an investment project which is located in a national security sensitive area, or to acquire share of equity in a local enterprise which have the land use right located in a national security sensitive area. Decree 31, which provide further guidance for the new law on investment, provide a list of national security sensitive area. The national defense and security review process can result in a rejection of the proposed investment or imposition of certain investment conditions, and which may significantly affect foreign investment into project or enterprise located in the national security sensitive area.
Yes, thank you.
Yeah.
Well,
all of the, yeah.
Yeah.
Let's
So
go
please
on, please.
continue. Yeah.
Okay.
Yeah.
For all of the purpose, the Ministry of National Defense and Ministry of Public Security will have their sole decision to determine which areas a national security and sensitive area, as well as to approve the foreign investment in the area.
Yes.
Yeah.
That's your points, right?
Yes.
Thank you. And I think the foreign investor will really have to pay special attention to that issues. And I would like to ask the other panelists, do you have any issues, or can you share your observation on this one?
Thank you, Mr. To, for your sharing. And I think, to be honest, this is the question raised by many foreign investors since the newly adopted investment law. It creates a very unpleasant headache for them. But I think it's the right track to follow. It's similar to many developed countries' policy on protecting the national defense. One thing is that I think the law may be missing, or maybe some intentional from the regulators, is that it refers only to the target company which have been able to obtain the land use right certificate. So it means that when we come and deal with a circumstance in which the target company, they do not have the land use right certificate, but they only have some kind of land lease decisions or land allocation decisions, they might fall out of the scope of this governing purpose. And that makes the law seems to omit them from the governing scope. But still, the question remains, how do the licensing authority will interpret it? But to my experience, still only those with the land use right certificate are the main target of this clause.
Yes, thank you. And how about Mr. Yu? And Mr. Yu, can you hear?
Yes, yes, thank you, Hori. In my appreciation, I would like to add another point that's regarding the hidden investment or nominee arrangements. In the news law on investment, the investment registration authority may terminate an investment project that's based on an artificial civil transaction in accordance with the civil code. So that means if we apply this provision to nominee arrangements, a court's reading would interpret this provision as a direct attempt to limit the use of nominee arrangements for foreign investment. I mean, in other words, nowadays a project operated by a local company which is established and owned by a local person as the nominee of a foreign investor may face the risk of being unilaterally terminated by the investment registration authority, but not by the court. And especially true where the target entity register business line are not open for foreign investor. And also, I think it's very, it's especially true in the case of a real estate investment project, which is located in national security sensitive areas, as Mr. Tu had just mentioned before.
Yes, that's all.
Yes.
Yes, and thank you for your sharing. And we will just look at some notable changes under the new law on investment. And next, Mr. Tu, can I come back to you? Could you please name a certain hot industry or sectors in your experience, and which you think are attractive to the foreign investor?
But my observation, fintech, real estate, and renewable energy, though that foreign investor have paid attention to recent years, many projects in those sectors has been registered by foreign investor, including foreign investment fund in Vietnam recent year. those are the most sector that's attractive to foreign investor per my observation.
Well, I see that there are fintech and in particular the P2P lending business is a hotspot in the market recently. So what is the market access condition for fintech service under the current regulation?
Yes, as you mentioned, fintech is hot for now and attractive to foreign investor in recent years. Foreign investors have had their attention to e-wallet services or and P2P lending. However, within the scope of this webinar today, we will explore further about P2P lending. For that, let me help Bao to share his experience and observation in terms of market access condition for P2P lending under the current regulation. Appreciate Bao if you can share with us your experience.
Yeah, thank you, Mr. Tu. For B2B lending, as you may all know, it's been a very hot spot in developing countries, let alone Vietnam, and especially those investors from Singapore or even from mainland China. They invest a lot in B2B lending, and most of the players in the market currently, they try to fit themselves into the fully committed business sector in Vietnam in order to avoid or bypass the requirements on market access. Mostly they would register for a very general business sector as a management consultancy services. In particular to that is the financial consultancy service. However, I think from a theoretical approach, it would not be entirely correct. But because the lack of the clear legal framework as well as the absence of any guidelines, formal guidelines, they still operate within such sector. I would expect that the new Sandbox regime, which were expected to be released in this first quarter, would clarify the issues. And I think, from my opinion, one must register for a kind of CBC A13 in order to proceed with that business sector. But let's see how the Sandbox guidelines would walk us through.
Yeah, thank you, Mr. Tu and Mr. Bảo. And I think we may take a closer look to P2P lending at the third topic of today's discussion. Right. So now let's move on to the second topic led by Mr. Yu about licensing procedure. And I believe this is also a topic that foreign investor will need to pay much attention to. And Mr. Yu, can you briefly describe the general licensing procedure for incorporating the foreign investment company in Vietnam?
Yes, generally, there's 3 licensing steps to be taken. Step 1 is to apply for an investment registration certificate, and it takes 15 days upon submission of proper application process to obtain this kind of license. This time limit is not applicable in the case that the licensing authority seek in principle approval of the ministry in Hanoi City before deciding whether or not to issue this license due to the market entry issue, as Mr. Tu had just mentioned before. And step 2 is to apply for an enterprise registration certificate, we usually know as ERC in Vietnam, and it takes only 3 working days upon submission of proper application document to the licensing authority to be issued with the ERC. And at this step 2, once the licensing authority issue the ERC, the company information is also published on the National Business Registration web portal in Vietnam, so where anyone can search on general information about this company. And finally, step 3 is to do post-licensing formalities such as making corporate shield, opening bank accounts, and completing initial test registration. And at this step 3, I would like to have a notable issue is that the foreign investor is required by law to pay the capital contribution to the company within 90 days upon issue of the ERC as obtained in step 2. In addition to those steps, the company may be required to have other licenses, usually known as sub-license in Vietnam, so that it's able to legally do business in Vietnam. So to sum up, in terms of licensing term, if we include the term for the investor as well as the legal advisor to prepare the application dossier, it takes around 3 months in total in order to complete the company corporation.
Yes, I understand that the time you just said it's 3 months, and it's just the estimated time based on the law, right? It's not the practical time for.
This is a practical time, but in the case that the licensing authority would not seek in principle approval of the ministry in Hanoi, if the licensing authority seek in principle approval of the ministry in Hanoi, the time limit may be prolonged because the licensing the ministry in Hanoi may give supportive or not supportive opinions on the company incorporation.
Yes, thank you. And I just heard you said about the sub-license. So can you give some example in case where the sub-license is further required?
Okay, I would like to give 2 examples. Firstly, is about a good retailing company. If the foreign investor would like to incorporate a company engaged in a good retailing in Vietnam, it must have a trading license or a core business license. And also in the case this company has a retailing store, it must apply for a retailing outlet license for each store. Besides the investment license and the enterprise registration certificate, as I had mentioned before. And the second example is in the education field. There are more 2 important sub-licenses to operate a school in Vietnam, which are school establishment license and school operation license. And that means if a foreign investor decide to have a subsidiary to operate a school in Vietnam, apart from the investment license and the enterprise registration certificate, it's required by law to further obtain those licenses.
Yes, thank you. Thank you, Mr. Yu, for the 2 examples on good retailing and education business. And I believe that different business will require different types of sub-license, and the investor really need to seek the support from the local lawyer to make sure that they don't miss any type of sub-license, right?
Yes.
And now I would like to expand on the licensing procedure for setting up subsidiaries in Vietnam. What do the foreign investor need to prepare?
Well, the foreign investor just need to prepare and provide legalized copies of certain documents, and also provide some information about them and about the company to be incorporated in Vietnam, so that the legal advisor has information to draft application document for signing by the foreign investor. And in my experience, I think the legalization takes half of the time in the process of establishing the company in Vietnam. So my advice is that the foreign investor should take legalizing procedure as soon as possible. Right after the legal advice, provide a list of documents required for the company incorporation.
Yes, yes. And another issue that I think deserve attention to is the license required for foreign expats to come and work for companies in Vietnam. Can you tell us what they include?
Oh, yes, foreigners are with validity of 3 months for the purpose of entering into Vietnam first. And then for those who are foreign employees of the company in Vietnam, means who are recruited by the company in Vietnam, he need to have a work permit or work permit exemption subject to the case. And the visa and the work permits are compulsory in Vietnam. And in additionally, if the company, if the foreigner attend to live in Vietnam for long term, the company in Vietnam should then proceed to obtain temporary resident card. We usually know as TRC, so that the foreign expat and their family members who enter into Vietnam together with the foreign expats are able to live in Vietnam for a long term without renewal or reobtainment of visa. And in the context of COVID-19, I would like to further add more information that the licensing procedure nowadays for obtainment of visa is more complicated than before. To be specific, now there are 2 steps to be taken for obtainment of a visa. Step 1 is to obtain a written approval of the People Committee of the provincial city. And step 2 is to submit the application for visa at the Department of Immigration. And if the Department of Immigration agrees to issue visa, then they will inform to the Vietnam Embassy where the foreigner is living to issue visa. Furthermore, to be issued with the visa, the foreign expat should be fully vaccinated with at least two doses. And after entry into Vietnam, he must undergo the quarantine period around 3 days at a permitted hotel in Vietnam.
Yes, thank you. And now can I ask Mr. Yu and also the other panelists, Mr. Bảo and Mr. Tú? I believe that in your working experience, you may have encountered many notable issues relating to licensing procedures, right? So can you share some that you believe that may be helpful for the foreign investor?
Yes, for me, beside what I have just mentioned, I have a note which I'm usually asked by many foreign investors during the time I assist them company in Vietnam. That's about the legal rep. You know, to my knowledge, in most jurisdictions such as Singapore, BVI, a company doesn't have a legal rep. However, in Vietnam, a company must have at least one legal rep, and you know the legal rep in the company in Vietnam plays very important role because he represents the company to sign the business contract, to sign the labor contract, and to represent the company in litigation proceeding. So when the foreign investor set up a company in Vietnam, they should find a reliable person to act as the legal rep of the companies. And I would like to add that by law, a foreigner or a Vietnamese person can be the legal rep of the company in Vietnam. It's subject to the decision of the investor, provided that the company must have at least one legal rep reside in Vietnam. And in the event of have more or two legal rep, the chapter, I mean the constitution of the company needs to separate and specify power of each legal rep. And in this, I think Mr. Tú and Bảo also have more interesting thing to share that they have drawn from their practice. So, Anh Tú and Bảo, can you share something in this question as we asked?
Yeah, thank you, Anh Yu, for your sharing, which is very interesting. I just want to add something about how the foreign investor will transfer their funds into Vietnam, because that's a very hot topic that many clients inquire about. So in Vietnam, when speaking of the transfer of funds, then we speaking about two types of investment accounts. The first one is direct investment account, and the second one is indirect investment account. They both required by the State Bank of Vietnam for the foreign investor to transfer their funds, to withdraw their funds from Vietnam, to be in short, to do anything with their funds in Vietnam, they need to be directed through that account. So as of 2019, when the new circular released, most of the account whereby the majority of positions happens, they would use the direct investment account. And it's a very vital thing, because if I have witnessed so many foreign investors, they transfer the funds not through these accounts, and it results that the tax authority, the licensing authority, they don't recognize that the investor has contributed capital, and therefore when they try to recoup their investment, or they try to eject their investment out of Vietnam, it is impracticable, and the banks do not allow them to do so. So it's a very, very important issue that we need to be attendant. Yeah.
Okay. So for me, in addition to what you and Bao have just shared, I would note that foreign investors should pay close attention to post-licensing compliance requirement after obtainment of the license for project registration or subsidiary incorporation to keep the business out of trouble. I usually see that foreign invested companies fail to make and submit investment report to the DBI, or report regarding to foreign loan to the State Bank of Vietnam, and such failures in most of the cases lead to the imposition of administrative monetary fine or restriction or delay in settling other required licensing procedure at the DBIs for chain of investment project, or at the State Bank of Vietnam for registration or chains of foreign loan registration.
Yes.
That's also important. Yes.
Yes. Thank you very much for your helpful experience. And now let's elaborate on the final topic on marketplace lending regulatory environment, and led by Mr. Bảo. So Mr. Bảo, what is the current regulatory status of and the framework in Vietnam applicable to marketplace lending? In other words, is the marketplace lending entirely legal in Vietnam?
Thank you, Huy. I think it's a very tricky question. I don't think that anyone can answer it in one simple word, that whether marketplace lending is entirely legal in Vietnam or not. It deals with very many different legal issues, and up to date, no peculiar rules have been set out by the by the government or the State Bank of Vietnam. None of these can be found. Most of the marketplace lending players in Vietnam currently, they operate on a very simple and general rules set out by the civil law or the law on commerce. So basically, they try to drive their model into the business that fit the permitted sectors. So I think this is the point where the role of lawyers advising the entrants are particularly important, because we need to deal with many different legal issues which lies in different sectors of law that is and are still in gray area. Yeah.
Yes, that's right. I agree that the roles of lawyers is absolutely significant at this point. So as a lawyer, do you see any legal issue that you think may in any way challenge the legitimate operation of a marketplace lending platform?
Yeah. So I think when marketplace lending first set their foot in Vietnamese market about five or 6 years ago, the first questions that the regulator and also the public raised is about whether they engage in banking activities. So in Vietnam, banking operation is very restricted. They only restricted to credit institution, the very licensed one. And but I think with the new development, the government and also the public has a different look on their true nature. So it means they are an intermediary platform rather than someone who going to lend directly the money. So the true nature has been recognized to the fullest extent that I understand. But it brings some other complex questions on their business model. When they run the business model, they can be treated as portfolio management activities, which currently restricted to the security company. And they could also be treated as entrusted lender and still the one that must be conducted by credit institution. And most recently, I think the issues related to they engaging in collection on behalf or payment on behalf have been significantly discussed. This issue, I say, is important because it's not only in the fintech area, it's also in e-commerce platform where they collect on behalf of their customer and they make payment on behalf of their customer. So this is an issue of the I think of the digital world. And the last thing is that about debt collection service, whether they engage in debt collection service or not. And this question is even more prevalent in this year since debt collection service has been prohibited by the new law on investment. So any who's going to engage in that, they really wants to avoid themselves being treated as one of them.
Yes, thank you. So in your opinion, what are the future regulatory prospects for marketplace lending?
Yeah, so future, I think most P2P platform they operate in the market right now, they feel more secure, not because they operate under more specific rules, but because they know that sooner or later the government will formalize their business model. And this I mean is the upcoming sandbox regime. The sandbox regime has been pushed back by the government for years, but according to the latest news, I believe that it would not be until the end of the first quarter of this year that the government going to issue a formal decree regulating the sandbox.
Well, let's wait and see what's coming. And can you name some main criteria set out by laws for a successful entry into a sandbox?
Yeah, sure. I think we can name it by law because there's currently no laws on that, but there may be the latest draft prepared by the State Bank of Vietnam. They set out about 5 or 6 main criteria that they will assess where an applicant related to fintech they have to apply. Because due to the limited station of time, I would not be able to analyze all 6 criteria, but I think the 2 important things is that the government is really care about is the P2P platform must bring the benefits for the service user in Vietnam, and especially the solutions for supporting and promoting the goal of financial inclusion. And I would like to emphasize the terms financial inclusion. It has been a macro policy adopted by the Prime Minister for many years ago. And when it was promoted, e-commerce has been rocketed. And now it is the time for fintech. And when the applicants, they apply for Sandbox, they need to demonstrate how they will fulfill the goal. and how they will help the government to achieve that goal. So that's the first thing. And I think the second thing that they need to care about is about the risk management. So the risk management is that they must not be a competitor or the challenger to the conventional credit institution. So every developing country, they have a quite weak financial system, and any new market entrants will pose a risk to the incumbents. So that's how you demonstrate that the peer-to-peer lending is only fit into the niche of the financial market. They don't really creating a negative impact on credit institutions. Yeah.
Yes, this seems so broad, and we may need further with more time to elaborate this.
Yeah, sure.
So in your opinion, which factor would you think that the investor should draw attention to?
Which factors? I think there would be many, but I would say two things. First, the first is customer protection. So many jurisdictions, they have their own mechanisms to protect the customer funds from being abused by the P2P lending platform. And the applicants, when they enter into the sandbox, they need to build up a similar mechanism that fit into the Vietnamese law, something like building an escrow account, or you can see some concept in common law like a trust account, but that's not workable in Vietnam. So I think they need to build some kind of escrow account to protect the customer funds. And on the other hand, because fintech is about the financial and technology, so the element of technology is another important thing. So when a peer-to-peer lending platform, they demonstrate that they would fit into the sandbox, they need to demonstrate that they employ the high-end technology, the algorithms and the API to analyze the risk, or not only credit risk, but also the geographical risk and many risks that associated with their business model.
So I have just one more last question for you. What are the decisive factors for a successful entry into Sandbox?
I think the successful entry into Sandbox requires many factors. Apart from what I have just mentioned, I would say that the experience of the investor is a vital thing. From my experience, the State Bank of Vietnam, they really dedicate to those who have their platform being tested elsewhere in Asia or even in Europe. So if an investor, they have subsidiaries that having operated the same business model in like Singapore, Indonesia, India, or anywhere else, and they can demonstrate the profits and the benefits that they bring, then it would be a plus point, a very much plus point. And the second thing is they need to demonstrate and present that they have the clear exit strategy. So when and if they fail to apply, they fail to achieve some kind of graduation after the sandbox, how can they dissolve? How can they deal with the customer they have represented? And this is also another care for State Bank of Vietnam. Yeah.
Yes. And Mr. Yu and Mr. Tu, do you have any sharing relating to the issue that Bảo had just presented?
I think that what Bảo had shared on the notable point regarding P2P lending that that foreign investors should pay attention to. First, they want to invest in Vietnam in that sector.
Yes.
Yes, and also from my personal view, I think I agree with Tudas about had points out many interesting in relation to lending. So I think we will clarify some a question from the audience today if they would like to investigate in more detail about this topic.
Yeah, sure. Well, then I would like to send a thank you to all the panelists for the panel discussion. And we will end the panel discussion here to move on the Q&A sections. And okay, let me check if there's any questions collected yet. Okay, I got one question here. I think it should be for Mr. Bảo to answer. Our question is about the direct investment account. According to Mr. Bảo, the direct investment account is required for transferring funds from investor in Vietnam. However, when the investor first enters into the market and carries out research as well as all the pre-investment activities, which means the paying the deposits for the landlord, would the expense be reflected as part of the investment fund and on the direct investment account afterward?
Yeah, I think it's a very interesting question. So let me recap it if I understand it correctly. The question is about the pre-investment that the foreign investor pour into Vietnam before they have achieved the investment account. So they move the funds in Vietnam through a non-residential account, or they move the fund directly to the service provider here in Vietnam to prepare for the investment. Am I correct?
Yes.
Okay. So there's a whole way provided by the law saying that foreign investment are entitled to pour in funds before they even establish an entity in Vietnam, and that means before they have the investment account. So the pre-investment funds would be accounted for when the investment account has been opened. That's the whole way. However, the whole way is not guided by anyone. I mean, the whole way is they don't provide clear guidelines how to do that. So we have to operate under assumption that the investment account is operated, is controlled by commercial bank in Vietnam. And it's really a matter of practical interpretation from each commercial bank we deal with. So it is highly recommended that before do engaging in transferring funds or even doing the investment in Vietnam, foreign investors are recommended to consult with the bank where they intend to open the investment account to see the formalities associated with the transfer and the conversion. Yeah, I would say banking consultation would be in prior.
Yes, true. Thank you. And I think Bao's answers is like quite clearly for your questions. I hope you were satisfied with Bao's answer. So I have another questions, and I think this one will be for Mr. Tu to answer. I read the questions. I believe that to obtain opinion from the Ministry of National Defense or the Ministry of Security would be challenging. So would you share with us your experience in relation to this?
The question is interesting. Yes, my point of view is it really challenging to obtain the opinion from the Ministry of National Defense or Ministry of Public Security. One of the transactions recently I have been involved in is a corporate bond, whereby the bond will be converted into a share of a local George stock company. And because the local joint stock company have land use rights located in several cities and provinces nationwide, so the DPI, in particular the DPI of Ho Chi Minh City, they seek for opinion from the Ministry of National Defense and Ministry of Public Securities. At first, we just estimate that it would take us about 3 or 2 weeks to have opinion from those ministry, but in fact, it takes us more than that, much more than that. I remember it took us about 5 weeks to obtain opinion from the 2 ministry, and it interesting that because the target company, the local joint stock company, have land use rights in various provinces. So at first, when the DPI sent the letter seeking for opinion from the Ministry of Defense, the ministry rejected that letter from the DPI, and it's request that the People Committee of Ho Chi Minh City have to be the entity sending the letter to them, not the DPI. So it takes us another periods of 3 weeks for the second round. So to sum up, I think that it's quite challenging because the timeline is not clear, and in practice we cannot predict how much time we have to spend for that procedure.
Yes, thank you. Oh, and I'm sorry, I forgot to mention the name of the questioner. For the first questions is Ms. Vong, and for questions that Mr. Tu had just answered is from Ms. Wing. So I think Wing, you can, are you still here? And I think Mr. Tu has tried the best effort to answer your questions. And in practical, it is hard to say the correct timelines for your questions. So I have collected another questions from Ms. Như. For the Sandbox, the panelists mentioned about establishing risk control measures in the application for Sandbox. What type of risk control measures should the investor pay attention to? I think this question will be led to Mr. Bao, right?
Yeah. Thank you for your questions. Risk control measure, I suspect that it would classify into 2 different categories. The first one is though applicable to its own business model, and the second one is applicable to the period, the specific period that the Sandbox runs. So for the risk control measure that's being applied to the business model itself, I have demonstrated. I trust that your question referred to those applied to the Sandbox period. So for the Sandbox period, like many other jurisdictions, they may require, the SPV may require the applicants to proactively build up the limitations. They may control that if one is allowed an investor onto the platform to invest, they must demonstrate, they must prove that they have sufficient funds, and they need to meet a minimum income, or even monthly income or yearly income to become an investor. The second limitation that could be linked to a geographical one. So when it's on board Sandbox, it may not be released in nationwide. It may be strictly to like some big cities like Ho Chi Minh City, Hanoi City, or Da Nang City, or some very in a geographical limitations. And yeah, I think these are the risk to build, and even they may set a cap on the disbursements, the total disbursement on an annual basis, or the total funds that mobilize from the investor. So I think that's the risk that the SPV is trying to build up, and to contain the risk that could be exposed if the tested subject fail to deliver their model.
Yes, thank you. So I have the last. I think this will be the last questions because our time is running up. So this one is from Mr. Bruce from Germany. Okay, let me read the questions. I think this will be for licensing procedure, and Mr. Yu can answer this one. I come from a company based in Germany. Our company manufactures refrigeration products. We intend to set up a company in Vietnam. Please kindly advise which license we need and how to obtain them. Also, in terms of management structure, could you please let us know which is the mandatory so that we can arrange our personnel to take those positions? Thank you.
Well, thank you, Huy. I understand that for this question, I understand that the company in Vietnam to be incorporated would be wholly owned by the Germany companies. Also, though the investor doesn't let us know which business line that they intend to register for the subsidiary in Vietnam. So I guess that it is the good trading because I think we will set up the company in Vietnam to import and the good as a manufacturer by the company in Germany and or US to import the product into Vietnam for distribution in Vietnam. And so if that's the case, the licenses to be obtained for incorporating the Vietnam company are firstly to obtain an investment registration certificate. Secondly, to obtain an enterprise registration certificate. And thirdly, to do post licensing formalities such as opening bank accounts, as I have mentioned before. And also in the case of in the case that the distribution of the Vietnam company include retailing, they will sell the product to the end user rather than to other traders. So then the fourth licensing procedure is to obtain a trading license. And furthermore, if they have retailing store, they need to have a retailing outlet license for each store. In terms of management structure, given that there is only Germany company which is wholly owned the Vietnamese company, so the Vietnam company must be in the form of a sole member liability company, and in such case, the management structure of the company would comprise a member council, a company president who represent the capital contribution in the company, and one director, usually known as the CEO. And the notice point is that the company only has one director. In a simplest case, the investor may appoint only one person to be the company president, come director, and also come legal rep of the company in Vietnam.
Yes, thank you, Mr. Yu. And I think that's to wrap up the discussion today. And we have some more questions over here, but the time is not allowed. So please submit your questions to the email info@tnd.com, and the panelists will try their best to answer your questions. Thank you again for attendance.
Thank you very much, Mr. Hoy, for this excellent moderation. I think this was a very informative session. I'm speaking from WLA, and my greetings to each one of you, the moderator, the panelists, and also those of you who are listening in. This useful discussion will be shared on social media. We've recorded this for the benefit of all those who want to learn more about this. So with that, thanks once again, and wish you all the best. Thanks for participation.
Yeah.
Bye-bye.
Thank you very much.
Thank you.
Thank you.
Okay.
Thank you.
Thank you.
Bye bye. Bye bye.